Good morning, everybody. The Senate Finance Committee is in an informal, I don't know whether we call it a work group, but a study group mode to understand a major piece of legislation that we have not yet had the hearing on, so that we'll understand the parameters of the.
We've had a hearing.
We did. Okay. So that we'll understand the parameters of the bill because it is complex. And we are dealing this morning with Senate Bill 275. There are several documents on your desk. I'm going to ask David to tell us what we have on the desk, and then he's going to kind of walk us through the bill.
Okay, to set, the idea here is to take up the bill with the amendments in front of you, not take up, but to go through the bill with the amendments in front of you. These amendments are from the sponsor and the president. They were working with representatives of both sides on this bill to come up with these proposed amendments in the bill in front of you. I'm not going to say whether anybody approves these or not. You'll have to find that out for yourself. I'm not going to speak for anybody, but the president and the sponsor worked with both sides to come up with this packet in front of you. Senator Kelly also asked that the following information be put on your desk for your review at this point. Nothing will be voted on here. This is just to go through this, and then and after we go through this, if you have any other things you want to talk about, certainly you can bring that up for the committee to discuss. Senator Kelly passed out three things. One is regarding the effect on behavioral health providers of this bill. The other one is from Ken Capone, and who's with Time to Care, and about self-direction and how that would affect those folks who are in those circumstances. That's one I have to talk to Ken about that, because I'm not quite sure how this self-direction works. And then the last one is from this is from the Max people and how this bill would affect them, and they're requesting an amendment also. But again, these are all things you can discuss later once we go through the bill in front of you with the amendments offered by the president and the sponsor. So are we all ready here?
Do I have the package from you?
It should be on your desk. Is the reprint not there?
You've got your
Okay,
hand up.
okay.
Okay.
Go ahead.
So you all have a reprint of Senate Bill 275, Time to Care. This is essentially a paid family medical leave proposal. So what it does is for long-term leave, you would get reimbursed for part of your income you would be missing if you took this long-term leave. The payment for this leave, the payment while you're off on taking advantage of this benefit would come from a fund, which would be funded by funds from employers and employees. So you don't get paid by the employer while you're on this leave. You would get paid by this fund, and there's all these parameters in this bill about how that would occur. So 80% of this bill is how do you implement the program. And then I think the thing that most people are going to be interested in is the 20% about who pays, how much, who is covered, and all those things. So we can start with page 2 of the reprint in front of you. Some of these definitions are key to the rest of the bill. I'll highlight the most important ones. If you go to lines 24 through 29, you'll see there's a definition of covered employee and covered individual. A covered employee is someone who works approximately, I'll say this, about 12 hours a week for an employer. And an employer is any employer with one or more employee for the purposes of this act. So the 12 hours per week is about the same as there'll be some comparisons here to the Healthy Working Families Act, which is provides, if you're 15 or more, you get paid, up to 5 paid leave days a year, or if you're 14 or under, you get unpaid leave 5 days a year. But the 12 hours, you have to work at least 12 hours for an employer to be a covered employee for the purposes of this bill. The next definition is covered individual. The covered individual, there's a provision in here that allows independent contractors to participate in the program. They're not employees per se, so covered individual would be a covered employee and a independent contractor. And covered individuals are the people who are going to be assessed, have an assessment provided against their income to pay into the fund. And as I said at the bottom, you'll see employer means any person or government entity that employs at least one individual in the state. If you go to page 3 of the reprint, there's a definition of family member. It consists of 10 parts. This is consistent. This is the same definition that is in the Healthy Working Families Act. So there's a biological child, child for whom the covered individual has legal or physical custody. But you've seen this definition already under the Healthy Working Families Act. It's the identical definition of who is a family member. At the bottom, there's a definition of next of kin. This relates to military leave benefits. On page 4 of the reprint, there's an extensive definition of qualifying exigency. Senator Jennings will probably help me with that word. And there's a series of steps that are a series of provisions here that relate to this circumstance when somebody can use this program to take leave in the event of a service person's, and you'll see how that all factors out here. On page 5, there's, as we'll see eventually, what you can use this leave benefit for. But one of the things you can use it for is a serious health condition, and that's defined on lines 5 through 17. So it's inpatient care, continued treatment of supervisor of or supervision at home. At the bottom of the bill, treatment is defined, or at the bottom of the page, treatment is defined. You'll see that runs through to the next page. So if you have a serious health condition, it includes some kind of treatment, then you would be eligible for the benefit in this bill. Let's see, if we go to page 6, lines 3 through 13, this is usual, when you deal with a lot of confidential information, this provides for that, how employees who would be working for the Maryland Department of Labor would have to deal with this confidential information. The scope of the title, who is actually going to be covered by this, or some of the specifics that are going to be covered by this. This, from lines 15 on down to the bottom of the page, this involves self-employed individuals. So if you're an independent contractor, you can take advantage of this program, but your participation has to be at least 3 years, and after the first 3 years, you would renew on an annual basis, for a yearly basis, and you would have to pay the same assessment as other employees in the state into the fund, so you can take advantage of the program.
Let me just butt in and say, if you got a question or you need greater explanation, raise your hand. Yeah, I think we need to be sure we understand what the bill is doing. Yeah.
Thank you. Do I need to put this on? Sure. Okay. Thank you. Thank you. The self-employed thing is, what bothers me is, I was a small corporation, and at the end of my time, I was the only employee. So according to this, I would have to pay this on myself, even though I was not ever going to use it. I mean,
It's optional.
well, I thought earlier it defined it said at least one employee. So when you're a corporation,
Oh.
you are the employee. So I was paying outrageous unemployment rates with the change with COVID that I had to pay because I was an employee of my corporation. All I was doing was taking deferred comp. I was never going to be able to claim that I was laid off or unemployed. So I have a problem with that part of the definition, which sort of carries over to the self-employed.
Yeah, again, that's the obviously you all can discuss that, and
Okay.
but yes,
In other words, we aren't evaluating, but we want to be sure we understand
Okay.
what's here, because some of it is very interesting and some of it is quite novel.
Well,
Okay.
interesting, Madam Chair. Thank you for that.
it's never come up. That's a good issue. So, and then, okay, so we're back to the independent contractors who can elect to participate in this program. It's not mandatory for them. And the bottom of that page on through the next determines how that participation will be handled. If you go to the top of page 7, lines 2 through 4, this specifies that if they elect to participate, they'll have to pay into the fund based on how a determination by the administrating agency, which in this case is going to be the Department of Labor. If we go down to lines 5 through 17, this concerns collective bargaining agreements that may be in existence. If you're under a collective bargaining agreement that covers paid leave, you would still be bound by that. The employer would still be bound by that collective bargaining agreement too. And
So you're
line,
saying they'd be in two different plans concurrently?
well, it reads here that may not be construed to diminish the employer's obligations to comply with a collective bargaining agreement or an employee policy that allows an employee to take leave for a longer period of time. So it specifies that if they have a better leave program than what's in this bill under the collective bargaining agreement, they would have to be obligated by the collective bargaining agreement, not by what's in this bill. The lines on 12 through 15, this also involves collective bargaining. An employee's right to benefits under this title may not be diminished. So if you're negotiating for collective bargaining to come to an agreement, you can't negotiate something less than what would, at least something less what's in this bill. You can always negotiate a stronger package, but you can't go less than what's in this bill. This bill is basically, for any existing paid family leave plan in the state offered by an employer through a collective, this would be the floor. You can't go lower than what would be in this bill. And that's similar also to the paid family, the Healthy Working Families Act too. On lines 17 through 18, there's some new language here. This was part of the negotiated agreement. Oh, you also see there's a change in the date. We'll be getting to that later, but this date had to change based on some of the changes in the dates later on in the bill regarding when fund collections will ensue and when benefits will be paid. So this date here is consistent. That change there had to be consistent with those dates coming up. Negotiated language here through the amendments that says here that the terms and conditions and benefits of this title are presumed to be equivalent to the terms and conditions of leave benefits under the Federal Family Medical Leave Act and temporary disability benefits under Title IX, which is workers' comp. The idea here is that whatever regulations, there's a lot going to be left to regulations here for the department when they develop their regs. It has to be consistent with these things unless this bill specifies otherwise. So if the law specifies otherwise, it's going to be the law. But as they go through everything else, it has to be at least consistent with the Family Medical Leave Act primarily.
I'm wondering in the long run for the department, after we're done today, if we could have some kind of a chart to say under which circumstances the leave programs that now exist would remain and which ones they would be subservient to this, and if they ever are superfluous, you know.
Okay, I'll look into,
Okay.
there's a lot of individual leave programs out there. I think they would probably all kind of work, separate and distinct. I mean, there's no program like this in state government for people who work in the state of Maryland right now, other than the unpaid FMLA, which only applies to employers with 50 or more employees. So,
Well, is it the case that this could be mandated concurrently with some of those other programs?
that's covered in subsequent parts of the bill.
Okay.
Let's go down to the bottom of page 7. This establishes the program. So there's nothing really unusual here. It says there is a family and medical leave insurance program. We'll call it family for short. That's become the term of art. On the bottom of the page onto the next page, this is the reasons you would be taking the benefit, accessing the benefit and paid leave under this program: to care for a child during the first year after the birth of the child, to care for a family member with a serious health condition, to take time off if you have a serious health condition and are unable to perform work, to care for a service member who is a covered individual's next of kin. That's where that definition comes near about who is next of kin. And because the covered individual has a qualifying exigency arising out of the deployment of a service member. So those are the 5 reasons you can access the benefit under this program. Next, we go to the administration of the program. It's going to be administered, the program is going to be located in the Maryland Department of Labor under the supervision of the Secretary. The Secretary may delegate any employee of the department to implement the program. So it's left to the Secretary to come up with a scheme to implement the program. The rest of this concerns the regulations that the Secretary will have to promulgate to implement the program. And you'll see if you go down to the middle of page 8, the Secretary shall adopt regulations. The regulations shall include procedures and forms for filing claims, procedures for notifying an employer. Here's an amendment that was negotiated. It was within 5 business days after the employee files a claim with the Secretary for the benefit. If that's been increased to 30 days, so within 30 days, this is consistent with FMLA. But there's a possibility of beginning the benefit prior to that 30-day, before that 30-day period, and that would be if the employer allows the employee to use the benefits under his title for the date of treatment for a serious health condition. So if the person requires treatment prior to that 30-day notification period, they can start the benefits sooner. This is also consistent with the FMLA. There's various regulations regarding notices of elections by self-employed individuals for benefits, information sharing.
I just have a question, David. It says here, if treatment for a serious health condition for the employee, it's not for a family member?
No, just for the
This
employee.
is just exclusively, that's the only way?
Yes.
Is for the actual person?
Yes.
To get under the, okay, thank you.
If we go to page 9, there's more about the regulations that the Secretary will have to promulgate regarding this. Lines 4 through 8 specify that, again, this reiterates that the regulations adopted under regarding the program shall be consistent with regulations adopted to implement FMLA and any relevant state laws to the extent that these regulations do not conflict. So if there's other state regulations regarding other leave programs in the state, everything has to be consistent in the regulations adopted by the Secretary to implement the program.
Senator Reedy.
Thanks. Yeah, on that point you just made, so we already have some regulations in state law that govern how we implement this federal act, or no?
The federal act, no, there's no regulations. The state, if you're subject to FMLA, you would be subject to FMLA
Oh,
regulations.
you mean they should be consistent with the federal regulations?
yes,
Okay.
yes.
Yeah, and, okay, thank you.
Okay, further on, okay, this involves certification. The rest of this page on page 9 involves certification. So you do have to provide some certification. So the way this is going to work is an employee who's eligible for benefits if they work more than 12 hours a week during the course of a year, or 12 hours, yes. They would apply to the Maryland Department of Labor for the benefit. Depending on what type of which one of the 5 items you're applying for, you would have to obtain certification for some of them. The only one that's not included on here would be the birth of a child. But for the illness of a family member, for your own illness, if you want to take this extended leave and get paid by the fund while you're on leave, you would have to provide certification to the department. And it would be left to the department to determine what kind of certification you would provide. But the certification has to include at least these items. You'll see lines 12 through 20. So I would imagine one of the certification required by the department would probably be some sort of health provider document that, this has to be done for you, or you're sick and you can't work. So all this involves the certification. The rest of this page involves the certification you have to provide to the department in order to access the benefit. If you're taking it for a family member's illness, your serious illness, or a serious illness of a military member. Going on to the next page. The top of page 10, lines 1 through 6, as you'll see, there's going to be a fund created by this bill. The intent here is for eventually all the money in the fund to fund the program, the administration of the program. That's what those lines involve. Further on down, there's enforcement provisions, obviously, provided for the Secretary to enforce this bill. They can conduct investigations, issue subpoenas. That takes you down to the bottom of page 10. You go through the next, there's more enforcement provisions and more enforcement authority granted to the Secretary. Lines 10 through 18, if there's a civil action to enforce this title, the secretary may be represented by the attorney general or a qualified attorney. This is not something they wouldn't do anyway. At the bottom of the page of 11 to the top of page 12, there's an annual report required, and you'll see what items that they have to report on from the bottom of page 11 through page 12. Next, on the middle of page, or sort of towards the middle of page 5, this is the language that involves this establishment of the Family and Medical Leave Insurance Fund. A lot of the language in the next couple of pages involves the creation of a special fund. It's canned language or that we put in there for every special fund. But, obviously the fund has to have revenue sources. And if you go to lines 15 through 19, I think this is probably one of the things you're more interested in, and see who has to pay into the fund. So it'll consist of employee contributions, self-employed individual contributions, and employer contributions. Those would be the main revenues. There's interest and all kinds of, any other source if somebody wants to give money to the fund. That's the usual language you see with any special fund. Again, going to the next page, this is language in here that governs special funds generally. So this applies to almost all these type of special funds in state government. At the bottom of the page, 13, is when you get paid your benefits, when you get your income replacement while you're on leave, the check will come from the state. That's at the bottom of the page. Go to page 14. I think this is where a lot of interest is. This identifies the actual
Excuse me,
contributions to the
Senator
fund.
Reedy.
I'm definitely interested in what you're about to get to, but I had a question before we dive into that.
Okay.
Okay.
On page 13, the fund may, on line 1, you mentioned the fund, this is standard special fund language, right? So this is a special fund. I see C, the fund may be used only for the purpose of this title. Does this act as a lock, sort of a lockbox on this fund? Can it be rated? Can money be moved in and out of it in a budget crisis or something like that, like we've seen years ago?
You would need a BRFA. So no, it's not locked in like you've locked in education funds in the Constitution.
But there's no way to do that without a constitutional amendment?
I believe so. I have to talk to somebody else about that, but obviously you could, if there's you would need a separate piece of legislation to take money out of this fund to alter this if you wanted to do that. So it would have to be a BRFA or something like that. Otherwise, no, you just can't budget the money. You just can't move the money out through the budget.
My concern is that, right now we're flush with cash, but it's one thing to move money out of the tire fund, when you need it to get in a pinch, but this is pretty important stuff. So anyway, thank you.
Okay, so on this, where am I here? Okay, on page 15. Oh, no, that's the benefits. I'm sorry. Let's go back to contributions, subtitle 6. So there were some changes to the bill as introduced here. These were part of the negotiated amendments. You'll see that initially the bill was introduced, contributions would start on January 1st, 2023. That has been moved back to October 1st, 2023, so it's a 9-month delay.
David, may I interrupt real quickly, please? You said that negotiated,
Between the sponsor and the president negotiated this with representatives of the business community and the advocates.
got it, okay, I was just trying to figure that out.
I see a lot of people shaking their head.
Well, it was primarily with the chamber.
Okay, just to clarify.
That's representatives of the business community, chamber. Okay, let's go along here. The total rate of
I
contribution,
think it was negotiated.
like I said, there was discussions, whether everybody, you'll have to talk to the folks who were part of the discussion, whether they approve or,
I didn't know whether this was House and Senate talking, or...
No, the House and Senate this is between the president, the sponsor, and folks that they were talking to on the bill. Let's see. Okay, so we'll go to what we're really talking about, what I think is of a lot of interest. These are lines 17 or 11 through 22. So all the way down to 24. So the bill's introduced, there was no change in the amount of money that would be, the total amount of an employee's income that would be assessed for the purposes of providing funds to the fund, to shore up the fund. It shall be applied to all wages up to and including the Social Security wage base, which is for 2022, $147,000 a year. So the max you could get for that 0.75% would be up to that amount of money. So the bill will be, the assessment will be shared by, the bill came in equally by employers because it was initially a 50-50 split. That no longer is the case. It shall be shared by employers and employees, so equally should be struck. And you go down
Oh,
to,
excuse me, Senator Jennings.
Let him finish, and then I'll.
Okay.
okay. Okay, so lines 20 through 22, you'll see that the employer share is dropped from 50% to 20%. And then the employee share is increased from 50% to 80%. So the employer will, out of that 0.75% of employees' wages, the employer will pay 20% and the employee will pay 80%. As this is a max, this is not set in stone. It can be less. It depends on, how much money is needed, what the anticipated use of the benefit will be. So this is as high as the assessment can be.
So my question is, when this was originally drafted, if the employee can't pay more than 0.75%, and they were contributing 50% to the fund, now they're saying they contribute up to 80%. How can you still keep it at 0.75% and match or meet the threshold that we have to have this account?
Well, originally it would have been 0.75% it's 0.75% of employees' income. Half of that 0.75% would be shared equally by the employer and the employee. So now you're still at 0.75%, but instead of 50-50, it's going to be 20-80.
Okay.
Yes, Senator
Yeah,
Goldman.
I'm going to throw some, into the mix here. So, it's specifically this provision that the contributions shall be applied to all wages up to and including the Social Security wage base. So, those you're only taxed on Social Security up to there's a ceiling, and that number is, what is it?
The same number,
No, I know, but what is the number? 140?
147,000.
So,
It varies
there's
by
nothing
year.
magical about that, and I guess one of the questions would come up as we're talking about the contribution mix here, is we're completely able to not be bound by that. We could establish a number higher than that 147. In other words, for folks who are making $400,000, we could flush this out a little bit. I'm just gonna throw that into the mix, that is a cap that, that number could be changed to bring in, a different mix and kind of money and hitting folks who are, maybe higher up on the food chain of income. And so, I have to think through this a little bit, but that is a 147 cap that could be, a different number. And I just, again, throw that into the discussion point here.
Senator Bottle, then Senator Reedy.
Thank you, Madam Chair. We're gonna need to do some math,
Yeah,
because I just did on 147,000, the employee would be paying like $91 a month. Well, no, they would pay,
They would pay 80%
80%
of
of
the
$91 a month.
Yes.
Suppose they choose to have their own disability policy. When you're making that kind of income, you buy disability insurance. I mean, we really have to crank numbers and look at this.
no, I agree. It's just that. It's just there. There's nothing magical
Right.
about that provision.
no, I
and the
agree with
number
you.
at 147. It could be higher or lower.
Okay. Senator Reedy.
So, couple of questions on this section. One is, so the 0.75 is the cap, right? Can't go above 0.75% of a person's wages. But it won't be the same amount for everybody, you're saying? So some workers, it might be 0.35% of their
No.
wages, some people it might be 0.6.
It will be, the cap will be whatever the department sets. The max, the fiscal notes and everything assumes the max, because that's the number you have here. So, the highest it can be, and it's easier just to deal with that right now. If through the actuarial studies or whatever analysis the department does, it turns out they don't have to go that high, you're still gonna be paying, every employee will be paying 80% of whatever that amount is. So.
Right, but whatever that amount is can't be more than 0.75%. That
Precisely.
80% can't be more than 0.75% of your paycheck.
Yes.
So when does the department set this, and how often do they set it? And can they just set it and just start changing it? Or what's the notification procedure for, let's say we get through the first 3 to 6 months and they need to change it, or does it set for a year?
If you'll see in the annual report, they have to, they have to report on this annually. So they're gonna have to look at this every year to, to see what the contributions are and whatever else they have to, whatever other information whatever else they need to make the program whole.
But can they change it like within that year? Can they, 1 month it's this and the next month it's that? Or is it gonna be an annual change, or do we spell that out?
That's not specified. I think the regulation, I think they would probably do it on an annual basis. I don't know why they would, look at it every month. But again, that's, it would be probably easier for the department to administer.
Well, I'm assuming so, but I'm just curious.
It's not specified how often they would have to, look at that.
Is there any, other than this report, is there any, like, once they say, hey, last year we took in this much money, we expended this much money, this is what's left in the fund, will that report, I didn't see, I looked at the language, but does that report say they're gonna lay out then what they're planning the fees to be the next year? Or would they release that separately, or, and what sort of like public commentary can be given on? Because I mean, I'm looking at, if you're making $75,000 a year, 0.75% of your wages is $562. So that's not nothing. I mean, it's not, stretch it over 12 months, may not seem like much, but for somebody making $75,000 a year, $562 is, and I understand it's a benefit they're gonna get, but, if you're making $55,000 a year, it's $412 a year that you'll be paying for this benefit. If it's up to 0.75% of your, I mean, it sounds like maybe it won't be that high, but if we start changing that, I just wonder, I guess my question is, what mechanism can we put in place to be sure that there is some level of the department? The first year we'll set it, it'll probably be fine. It's more like 3 or 4 years down the road, you're gonna have to make adjustments. So is there any language that allows the public to be informed in advance of what the new tax is gonna be, or the new fee is gonna be? And gives them a chance to give input on it?
I would assume this would all be in regulation, and they would have to come in with a change in regulations if they wanted to, go lower than 0.7, adjust it accordingly. I would think they would start off at least the first couple of years at the 0.75%, just simply because you have to capitalize the fund.
Yeah,
So,
makes sense.
and then, further on down the road, you could all be here too, to, if it's necessary to make adjustments here, statutorily on the cap. But, I would imagine the first several years, at the very least, they would be.
It'll be
at-
0.75.
Yeah,
And nobody will probably object if they want to lower it, but one day, right? I mean, if they want to say, okay, now we're just going to go to 0.55. But you were talking earlier, somebody was mentioning, so that's good, thank you. The other question that came to mind is that somebody was mentioning earlier that there could be, I think it was Senator Feldman was talking about, maybe you have different rates for different levels of income that could be set. Do we have any, that's not spelled out in the bill as of right now, so we're leaving that up to the department?
the law says that the rate of contribution may not exceed, shall be applied to all wages up to and including the social security base, so.
So there's no provision for a bifurcated or progressive structure?
Not that I can read right here now.
Okay,
That
thank
was-
you.
Let me just say that, I was just throwing that into the mix. I mean, if you made $1 million, you're capped at 7.5, but because of this provision, you're only up to the 147. I think that's kind of what I'm throwing into the mix here, a little bit of potentially maybe some progressivity, like right there, which is something to think about for the committee, so.
David, this is in addition to, this program is on top of the existing personal health insurance policies that people are carrying on their jobs, right?
Well, this is not health insurance. This is just allows
Well,
you to get paid while you're
Yeah,
on
but it's
extended
leave
leave.
because of other people's health problems.
Yes,
Okay, so.
that's
so-
one of the possible
So you
uses
gotta
of a.
remember, you got your own health insurance to pay for yourself and what immediate family or however you do it, and now this is on top of that.
Well, and the millionaire is not the one that we're doing, that the program is for anyway. I mean, it's really more about the person, the 147,000 and below is more likely to be somebody that
That's a fair point.
would need this.
Okay,
Let me ask one other thing. Have they done any actuarial analysis of what they're gonna generate, given people's behavior and the frequency with which various categories of people will be using it?
you know, obviously, but we'll see at the back of the bill, there's amended language about an actuarial analysis. But one would, you know, without even that, one would think that the department would be doing some sort of, whoever's administering this would be doing this kind of analysis anyway. But there's when we get to the back of the bill, there's specific language in there about an actuarial analysis before we even start the program.
Okay,
about
but let
what
me
you
just
need.
ask one other thing. What about a person who, when you look at that whole list of people that you might need to care for because they're ill, and it's kind of far-fetched to me, it's way beyond what normally we pay individual health insurance for. And then if a second relative needs you to take leave, can you do it? in-
Well,
in-
we'll,
within
there's,
leave year?
right now, we'll get to the amount of leave you can actually take, and if we can wait till we get to that part, then you can talk about that part when we get there.
Okay.
That would be probably more straightforward.
Okay, I'll wait till you get there.
Okay, so we're on the actual contributions. The main source of revenues for this fund, 75%, 80/20, between the employee and employer respectively. If we go to page 15 at the top, you'll see that the independent contractors will also have to contribute an amount equal to the total rate of contribution established under here. Again, that'll be left to the department to decide how much independent contractors will be contributing to the fund if they elect to participate. But it can't exceed 0.75%. So if you're an independent, obviously you can't exceed 0.75% of your income. Further on page 15, line 5 all the way down, these are the benefits that you would get from the money that would go into the fund. And the contributions were delayed till October 1st, so there's no contributions until October 1st, 2023. Benefits will not be paid from the fund. That is also delayed 6 months, from July 1, 2024 to January 1st, 2025. So benefits won't start being paid until January 1st, 2025. And the benefits may be the claim for benefits may be set for these 5 reasons, which were also detailed in under 8.3302. Care for a newborn child, care for a family member, attend to a serious health condition that results in you're being unable to perform your job, care for a service member, or to attend to a qualifying exigency arising out of the deployment of a family service member. At the bottom of the page, intermittent leave is also authorized under this program. And so an individual may take leave for which individual is eligible on an intermittent leave schedule. There are certain requirements regarding taking this intermittent leave. The covered individual shall make every reasonable effort to schedule the intermittent leave in a manner that does not unduly disrupt the operations of the employer, and provide the employer with reasonable and practical prior notice of the reason for the intermittent leave, that the intermittent leave is necessary. There's an amendment added here to say that the intermittent leave, this is the same language that's in the Healthy Working Families Act, but it's reversed. It says here that except as provided under the following language. A covered employee may not take intermittent leave in an increment of less than 4 hours, so you can't take an hour of intermittent leave. It has to be at least 4 hours. However, a covered individual may take intermittent leave in the smallest increment that the employer's payroll system uses to account for the services. But at the very least, it can't be less than 4 hours unless your employer has a fairly sophisticated payroll system that can track leave by the hour. And, the employee does that and the employer agrees. It doesn't mandate that the employer do that. Further down on the page, this concerns the length of the leave benefit, which is what we were about to get into. So a covered individual may not receive more than 12 weeks of benefits in an application year. That's consistent with the Family Medical Leave Act. A covered individual may receive an additional 12 weeks of benefits if the covered individual during the application year received benefits because the covered individual was eligible under A3 is your own illness. So if you were out for 12 weeks because you were unable to perform work, you could receive an additional 12 weeks if, for the birth of a child, for the care for a family member, if you're next of kin to a service member, or for a qualifying exigency. But you can't get an additional 12 weeks for your own illness. So the only way you can get the additional 12 weeks is if you were out sick first, and then one of these following conditions occurred within the same benefit year. So it's possible to get up to 24 weeks of leave.
Senator Augustine?
Thank you. So if a woman is pregnant, like how does that work here? I'm just trying to understand.
Okay, if a woman is pregnant, she's pretty much only going to get 12 weeks for her leave. But if a woman had been sick and was unable to perform her duties and had a serious health condition, and then subsequently there was, she was pregnant, then she could conceivably take an additional 12 weeks for that.
Okay.
But the first 12 weeks, this limitation only applies if the first 12 weeks were for your own illness.
Okay. But if a woman had a difficult pregnancy, because isn't there the care of the child also?
That's one use. That's one of the uses of the leave. I don't think we go into that kind. I don't think it.
I'm just trying to understand.
Yeah, no. That's not how this is structured.
Oh, okay.
I have a question, David. I'm back on page 3 again with the list of the definitions for a family member. And I'm looking at definition 6. An individual who stood as a parent or stood in locus parentis to the covered individual or the covered individual's spouse when the covered individual or the covered individual's spouse was a minor. Now, they're not talking about a person that you're related to by blood at all or by marriage. This list is pretty long. Would you have to register all of the people when you would take out the insurance who could possibly be the source of the use of the insurance at that time, or can you come up with these relatives? I'm just wondering how they could make an expeditious decision with this kind of a list. When you say, well, there's the person named Jane Doe, and they're my cousin or my this or my that, it's 10 different categories and with some subcategories of people for whom you could take the leave. And I'm just wondering, how would that work?
Well, I would imagine, like, as with the Healthy Working Families Act, since it's the same definition, you would go to the department, and you have to care for one of these people has a serious health condition and they're part of your family by definition, then you would have to go to the health department, make a request for the benefit, provide certification, and then
I'm
then
just
you would
thinking
get the
right now
benefit.
with the problems they're having in the health department right now with the computer
Well,
system.
this is the Maryland Department of Labor.
All right,
not
with
the- yeah.
labor, they probably would be in the same boat. I'm just saying, when you get a lot of people needing to use, and a lot of these requests come in a short amount of time, and you've got a list this long with many people being way beyond what normally for leave programs would be a consideration. If we would need to have this list put together for each person as a part of the paperwork when you join the program, so they would know that it's somebody that's pre-certified if you ever needed to help them by taking the leave. Or if you've got to wait around when you need to leave while they determine if this person meets the requirements, because it's such a long and amorphous list.
I don't think you actually join the program. It's not like insurance. You would apply and you would have to provide the paperwork that, this is why you want to access the benefits. So
Okay,
it's-
but I'm just saying, when I come up and I'm looking at number 6 or I talk to say somebody's a legal guardian, or that this is a biological grandparent or an adopted grandparent or a foster grandparent or a step-grandparent of a covered individual. If they really need the leave, they probably are gonna need to pre-register all of these people that in each insured's case could possibly ever be the source of their needing the leave, or else it wouldn't be received in a timely manner if they've got to, start documenting and look for things at the time they need it. It's really a really long and kind of drawn out list.
that,
I mean, I don't know if I'm the only one thinking that seems something that needs to be addressed now. As to when would these people be identified? In any other kind of coverage, you would kind of have a way of identifying who the people are when you go into the program.
Again, the only thing I would, and this is an assumption on how the department would administer the program, is they would ask for some information about each. If you're going in there for a adopted grandparent, then the department probably would want some documentation that is, really your adopted
I
grandparent.
mean, when you look at number 3, a child for whom the covered individual stands in loco parentis, regardless of the child's age. So you may be the auntie or the good neighbor who looks out for this child, but there's no legal relationship to the child. They've got such a long and amorphous list. I'm just saying, while we're working on it, we need to decide at what point would these people who, in the case of a given applicant, need to be identified? Is it when you're in trouble and you need to take the leave, and you might be waiting around and be finished with the leave by the time they could document, or you could provide documentation as to who this person is and if they fit? Senator Feldman.
Well, no, I think it would be good, because, obviously we got session coming up, to go through this, and you've just identified an issue, everybody's gonna read some issues, and then, we're gonna discuss it, so make sure we get through the whole bill before we gotta run out of here, is
Okay.
my only point here.
Okay. Anything else, Dave? Well, that's one I'd like you just to put down as an issue.
Okay, the definition of family member. So we're now on, where did we leave off here? 17? Okay, yeah, so we're past, the length of the leave. There's more information here, though. If a covered individual takes leave for which they're receiving benefits, the leave shall run concurrently with eligible leave that may be taken under the Family Medical Leave Act. So you can't do this leave and then get an additional 12 weeks under the Family Medical Leave Act. So you're limited to, this would be your Family Medical Leave Act benefit. Lines 22 through 28. Okay, if you're receiving benefits under a UI or workers' comp, that wouldn't apply unless, there's only one exception here. An individual receiving compensation for a permanent partial disability may be eligible for this benefit, otherwise, no. On the bottom of the page, to the top, there's additional language: an employer may allow a covered individual use existing paid leave to get full income replacement as part of the 12 weeks. Again, that's a may, that's not a requirement. And lines 5 through 6, again, we're reiterating that the employer contributing to the fund may require a covered individual who receives benefits to use those benefits concurrently with family medical leave. Oh, okay, this is similar to the FMLA. If the employer has their own policy, but they're still contributing to the fund, then they can require that those benefits occur concurrently also. Further on.
Senator Augustine.
I'm just trying to, again, so if a person they have vacation, they're saying, on the provision that you were just talking about before, this insurance would take up to X amount?
If
And
the
they could
employer,
backfill the rest to the,
yes,
basically?
yes,
But the
basically.
insurance pays first.
No, I think I would think they would take their leave first, and then the insurance would kick in after that. I mean, it depends on how you want to, I would imagine you have to arrange this as an agreement with your employer, how you want to do this. But there's no requirement that the employer do this.
Okay.
But I would think you would want 100% of your income, whatever that paid leave is, you would probably want that first, and then this would.
You get 100%, right?
Yeah, you get 100% income replacement, and then the rest of that 12-week period would be the benefit under the program. Okay, okay, now we're in the actual payment of the benefits. How much income replacement a person would get under the program. And these are lines 9 through 31. There's a lot of, it's not very straightforward to understand, but it does work. You have to take my word for it. But the bottom line is, if the state is required, that labor already has to calculate a weekly average wage under UI, so that it refers to that. So under the weekly average wage, the idea here is if you make less money, you get more of your income replaced. So we'll focus on those folks. If these covered individuals' average weekly wage is 65% or less of the state average weekly wage, you get 90% of that of that benefit per week while you're on the leave. And then it gets a little confusing after that, but the idea here is to give the folks who make less more of their money, more of their income covered than the folks who make more. We go to the next page. And there's also provisions here that are similar for partial leave. It's the same ratios, but it concerns partial leave, so you're eligible. You can take partial leave if you choose. Again, this would all be left up. The details would all be in the regulations promulgated by the department.
Senator Augustine.
Thank you, just in keeping with what Senator Feldman mentioned about there being the cap on on the one side, there's no cap on this side?
There is a cap.
Okay, there is, we're gonna
Yeah,
get
we're
to
going to
it?
get to that right now.
All right, great.
Okay. So lines 11 through 16 are the cap on page 18. So the least amount you can get per week is $50. That will stay set. However, the amount you get may not exceed for the 12-month period beginning, again, this deals with the delayed implementation date. Beginning on January 1st is $1,000. So the most you can get is $1,000 under this bill. Because, if you're making a heck of a lot of money, it's quite possible, even with the, so the most you can get is $1,000. The rest of the language and the amendments concern indexing that $1,000. So starting the year after, the department would have to index that for cost of living, that $1,000 amount, so it could change going forward. And that takes you down through the next page on line 17. This is just standard indexing language you see in the code.
Like what we do for gas taxes.
Yes, gas taxes, there's been, Well, okay, I don't know if we do that or not.
I just stay with
Yeah, yeah,
that.
anyway, yeah, okay. Lines 18 through 28 concern notifications for the department that has to provide as this process unfolds. So the department shall notify the employer of a covered individual within 30 days again. It was extended from 5 days after the covered individual files a claim for benefits. They have to approve or deny the claim and notify the covered individual within 10 business days after the claim is approved, and start making payments, make subsequent payments every 2 weeks until the benefit period ends. So you'll get a check from the state every 2 weeks while you're accessing the benefit. On the bottom of the page through the middle of the next page, this is done on a case-by-case basis, but it could be possible you have to pay taxes on this income, and this provides how those taxes will be handled. If you go to the bottom of the page, this is employer alternatives. So an employer may satisfy the requirements of this title through a private employer plan consisting of an employer-provided benefit, insurance, or combination of both, if the plan offered is greater than the plan in this bill. So a private employer can, get their own benefit, provide their own benefit, but it has to be at least this benefit in this bill. They'll have to notify the department that they're doing this, and then once they do all that, then they're not obligated to, the employees and employers are not obligated to be assessed the 0.75% under this bill if they do all that. On the next page, the top lines concern what happens while you're on leave. If you're receiving benefits or take leave, upon the expiration of the benefits, you have to be restored to an equivalent position of employment with your employer. Also, while you're on leave, you have to still continue to be covered by health insurance or whatever else you have under your employer. This is similar to FMLA requirements. On the bottom of the page, there are, obviously, employees have to be notified that this benefit exists, so their employer will have to provide notice to their employees. You'll see the details of the notice, but they don't have to develop, it'll be under a form developed by the department, so the department will have to develop the notice, distribute it, if the employer wants, they can access this notice, and they will have to provide notice of the employee's rights under this program. That takes you through to page 22. Starting on line 9 on page 22, there are obviously prohibitive acts and penalties for non-compliance on both parts. So if you're a covered individual and you're not meeting the requirements of the program, there are consequences. And if you're an employee, obviously, if you're not meeting the requirements of the program, there are consequences. Starting off, covered individuals have to submit honest information when they submit their information. They have to be honest when they submit their information to the department. If an employer there's fines if an employer provides false statements. At the bottom of the page, there are provisions here that authorize the department to seek repayment if benefits were paid erroneously. On the next page, there's penalties for an employer who failed to contribute to the fund. On the bottom of page 23 through page 24, is anti-retaliation provision. So an employer cannot retaliate against an employee who exercises their rights under this title. On page 24, lines 4 through 13, this authorizes an employee to file a complaint with the department. The middle of the page, civil actions are authorized for employers who do not meet the requirements of the program. And the secretary, and there's at the bottom of the page, the secretary is required to establish an appeals process for anybody who feels that they weren't treated fairly or did not get what they were supposed to get. They can appeal to the department. There's also provisions for judicial appeal also. On the next page, on page 25, the middle of the page, this is standard special fund language. If you create a special fund, you have to add them to the state finance and procurement. You'll see there's 146 special funds in state government if this would pass. At the bottom of the page, there's uncodified language, and this is where we're talking about. There's two issues here. the first issue that came up, that it's unclear what the status of these employees are regarding UI benefits when they're on this leave, and should they quit right afterwards or don't come back to work? Are they eligible? There's a study here, there's a study here to see how that will work. So depending on the outcome of the study, again, the benefits don't start coming in until, the fund doesn't start receiving benefits until 2024. Benefits don't start going out. So this study regarding how this could possibly impact UI is required on January 1st, 2023. So you'll have a session if there's adjustment that has to be made regarding the interaction between this program, if this passes, and UI. And then at the bottom of the page, the department is required to conduct an actuarial assessment to see, under the existing tax rate in the bill, whether that would be enough to fund the program, and get back to you in case any adjustments have to be made. That report is due October 1st, 2022. And then there's a delayed effective date for the actual program to January 1st. If you go to the very last page, we've got a blank page here. January 1st, January 1st, 2023. But then the act will take effect on June 1st, 2022, to allow, at least to get the actuarial studies going. And then you'll have at least another session to make any adjustments before the program actually, if the actuarial study says this isn't enough, then you'll have an opportunity to adjust the tax rate assessment as necessary.
Is a similar program in effect in any of our neighboring states?
In our neighboring states, New Jersey has one. New Jersey, New York, let's see, who has one? New Hampshire, Vermont, Massachusetts, Rhode Island, Connecticut, New Jersey. There's one pending in Delaware, I believe, and Maryland and DC.
If we could have a subcommittee, or if you had some time, to look at how the actual parameters of their programs match.
Information, I can distribute that information now, but
Okay.
I think the most important things, we can pass, I'll have, make sure you all get that about what's the contributions are, what's the maximum rate, what's the wage ceiling, and the maximum benefits. So we have all that right now, if we can
Okay.
pass that out.
Okay, Senator Kramer.
David, has there been anything done, and I didn't, and if I missed you mentioning it, all the concerns that have been raised from our developmental disabilities community with how they are worried about?
Yes, there's nothing in this package that addresses that. I know that, part of the three things you have on your desk from
Things that
Senator
came
Kelly
to me
are
and I
those
wanted to
concerns.
see 'em.
So certainly, that's something you all can discuss when you actually formally take the bill up.
Well, have there been any suggestions to date as to how that can be addressed? What-
I've seen an amendment already drafted, at least at a House bill, about the max concerns. So if, that's already been, there's paper already done on that one. I have to speak with Ken Capone, because I'm not quite clear what self-direction means and how that relationship works. So I'm going to try to reach out to them on that particular one. And then the behavioral health folks have.
Somebody like Barbara Vercotta could explain it, because they work with those people a
Okay.
lot, yeah.
And then the behavioral health folks have the same concerns, obviously, as the max.
And they
folks.
struggle so hard to do very important and challenging work, and I think we need to make sure we do address their concerns. That's a tough industry, so thank you.
Okay, yeah, Senator Plasmer.
No, I do have some amendments I'm gonna just give to you to, and it's about all that, so.
Okay. All right, well, we got session coming up. I appreciate your being here. We wanted to have an idea of what the bill's about.
Nathan would like.
Oh, yes, Nathan does have one quick notice.
Just a brief note about Senate Bill 789.